Okay, we've reached our decision, and Francesca will read it out.
So Rochford District Council, being the relevant licensing authority, received an application for a premises licence for the Chichester Hotel, Old London Road, Rawworth, SS118UE. During the 28-day representation period, the council received 12 representations from local residents. Essex Police agreed conditions with the applicant in advance, and therefore there were no representations from responsible authorities. On the 24th of June, today, a hearing was held to consider the application for the premises licence. The subcommittee determined, bear with me one second, gone down a bit too far. The subcommittee determined the application with a view to promoting the 4 licensing objectives. It considered the application in its own merits, and in reaching its determination, the subcommittee had regard to the 3 following matters. The relevant parts of the written and oral evidence before them, the Rochford District Council licensing policy, statutory guidance issued under the Licensing Act 2003. And the subcommittee also listened to the evidence and submissions it had from the licensing officer, the applicant, and the local residents. The licensing officer presented his report and outlined the application which had been submitted and responded to questions from all parties. A copy of the application was also attached to the report. The applicant presented their case and responded to questions from all parties, and the parties summed up. On to findings and determination. The subcommittee considered the evidence in the report as well as the written and oral evidence of all parties put forward in the hearing during their determination, and the subcommittee had due regard to the licensing objectives, most particularly the prevention of public nuisance, public safety, and the prevention of crime and disorder. The subcommittee had regard to the evidence in the licensing officer's report as well as those oral evidence of all parties put forward at the hearing and the relevant case law. The subcommittee was satisfied that granting an application, but with some variations to those proposed by the applicant, would not undermine the promotion of the licensing objectives, and the subcommittee wished that the following conditions be imposed. And it's tricky, I've put this into a table, so you'll get a copy of this, but we've separated them off into indoor activities and outdoor activities, and there is some variation in weekdays and weekend nights. So for the provision of films, indoors, 9 until 2 a.m. is granted. Outdoors, 9 until 11 p.m. is granted. For the provision of live music, Sunday to Wednesday, 9 a.m. until midnight, Thursday, Friday, and Saturday, 9 until midnight. On Thursday, Friday, and Saturday, 9 until 2 a.m., that's indoors. And for outdoors, 9 until midnight, Monday to Sunday. The same conditions apply for the provision of recorded music, the provision of dance, and the provision of late night refreshment. And for the sale of alcohol, the supply of alcohol, Sunday to Wednesday, 9 until midnight, Thursday, Friday, and Saturday, 9 until 2. Now, having regard to those 4 licensing objectives, the subcommittee were of the view that it is in the public interest to grant the application, but with those reasonable amendments. The subcommittee were also of the view that there was nothing in the applicant's submissions that gave rise to a concern that those conditions would restrict their ability to operate fairly. The committee gave great weight to the fact that no representations had been made by the police or environmental health, and that's correct under the case of on the application of Thwaites, and the full citation will be in the notes if you need to refer to that, which states that great weight should be given to the decisions of those representing entities as the experts in their area. The subcommittee decided that in separating the indoor activities from the outdoor activities and those weekday activities from weekend activities, the applicant could still make use of temporary event notices as and when their business requires. Now, of course, there is a right of appeal against this decision. That goes to the Magistrates' Court, and any appeal must be commenced within 21 days, beginning with the day on which you received notification of the decision. You may wish to seek independent legal advice from a solicitor or from the Citizens Advice Bureau if you do this. Thank you.